Hello, friends. Welcome back to the Legal Researcher. So, this is Test Your Knowledge and Experience Series 5. We are going to discuss some important questions and interesting questions on the topics of general defense, that is, general defense part 2, in which we are going to discuss the questions on these four defenses: inevitable accident, act of God, private defense, and mistake. So, friends, you have to analyze your performance on the basis of these performance analyzer scale. There are 20 questions in this series, all having 2.5 marks, means 2.5 marks each, total of 50 marks, and you can mark 0.5 as a penalty if you mark any option as incorrect in any of the question. So let's start with the question. The first question is, which of the following best defines an inevitable accident in tort law? So first, let's read all the options. Then we will choose the best option, because here the question is which is best defines an inevitable accident. So the first option is an accident that occurs without any human intervention. Second is an accident that cannot be avoided even with reasonable care. Third is an accident that happens due to natural forces. And fourth is an accident that is caused by intentional act of a third party. So when you analyze all these four options, see, this is a very easy questions, but at the same time it's a tricky one, in the sense that, if you apply more mind in the examination hall, you may not able to reach the right option. So for all these type of simple questions, you need to just keep your mind on the question. Just read the all the options carefully only one time, and just after reading one time, you will automatically, your mind will say to you which option is more close to the question, you know so you just have to tick that one, because that is the only correct answer. If you apply more mind, you will get stuck in that. So just reading it by once, you may analyze that option number B is very close to the question, because inevitable accident, when you study inevitable accident, the first thing that you read is that those accidents that cannot be avoided, and the second part, even with reasonable care. So that is the basic definition of inevitable accident. Now if you see the option number A, you may confuse, because the option number A says that an accident that occurs without any human intervention. So yeah, it may be an inevitable accident, but it is not necessarily. See, so this option number A is not perfect here. Option number B is rather perfect. So you have to choose option number B, because this is the most correct. This is the best that describe inevitable accident. Other options, for the sake of clarifications, other options are not, because see, the option number C is an accident that happens due to natural force. This is not an option. The option number D is an accident that is caused by intentional act of a third party. That is again not inevitable accident, because it is intentional act and it is due to natural force. It does not necessarily a natural force, है ना? It may be natural force, it may be human error, है ना? If it is purely natural force, then it is act of God. So this is something that we have to keep in mind. So option number B is the correct answer is option number B. The correct answer is option number B. Second question is, which of the following are essential elements to prove an act of God defense? The first option is the event was caused by natural forces, the event was unforeseeable, third is the defendant exercised reasonable care, and fourth is the event caused significant damage. See, if you again read all the four statements, you may realize that all may be true, because all are in a way essentials for the act of God. But when you look at the options, you see that no options have all the four statements. So it means that you have to eliminate any one of the statements. Now if you see carefully, you will analyze that option B and D have 1 and 2 both, because and there is a difference in the third part, that is 3, and here is the 4. So you have to think that which out of 3 and 4, if not present, there will be no issue in proving the act of God. So if you see option number 4, the event cause statement number 4, the event caused significant damage, it is not an essential as such for the act of God. Yes, damage is always very essential, but it is not in the option. So we have to eliminate, or rather we have to you know omit this fourth one, and so the correct answer is option number B, 1, 2 and 3. Third question is, in which landmark case did the court establish the principle of inevitable accident as a defense in tort law? The first is Relent versus Fletcher. Second is Nichols versus Marshland. The third is Blyth versus Birmingham Waterworks Corporation. And fourth is Stanley versus Powell. So, if you have read the books, you can easily sort out that the fourth option, Stanley versus Powell, is the correct answer. C. The explanation is Relent versus Fletcher established strict liability. Nichols versus Marshland dealt with the act of God. Blyth versus Birmingham Waterworks Company is related to a standard of negligence, and the fourth one, Stanley versus Powell, it is related to inevitable accident. The other question will have the questions with the this fact of Stanley versus Powell. So let's move further on the question number 4. Question number 4 is, identify the option that does not fit with the others in the terms of defense of inevitable accident. So option number, identify the option that doesn't fit with the others in terms of defense of inevitable accident. So this is a question basically of odd one out. You have to choose the statement or the option that is odd. So if you see all the options very carefully, you will find the odd one. The first option is a car accident due to brake failure despite recent servicing. Second is a dog startling horses leading to injury. The third is a bus accident due to a sudden appearance of a cyclist. And the fourth one is a flood causing damage to the property. So see, if you carefully read all these statements, you find that in all the statements other than the option number D, there is a human element. A car accident, a dog startling horses leading to an injury. This also contain human error or human element, because yes, if you read one case that we will discuss in different question also. Third is a bus accident due to sudden appearance of a cyclist, again human issues. But if you see carefully the D option number D, you will find that option number D, a flood causing damage to the property, is clearly an act of God, not inevitable accident, as an odd one out. So option number D is the correct answer. Question number 5 is, match the following. So match the cases with their corresponding outcomes. We have four cases: Stanley versus Powell, Assam State Corporation versus Srimati Anubha Sinha. The third is Holmes versus Mathur. Fourth is nitroglycerin case. So you have to match the correct one. Stanley versus Powell is something, a very important case in inevitable accident, and that is with related to injury due to pheasant sword glancing of an oak tree. One is correctly matched with the three, wherein Stanley versus Powell, there are other questions as well. So it's a very important case. You have to remember it anyhow. All other cases are also very important, you know. So one matches with three. There is only one option. So option A will definitely be correct. But for the purpose of clarification and for the discussion of this video, we will also look upon the other things. So second is Assam State Corporation versus Srimati Aruha Sinha. So if you see, the this is related to tenant not liable for fire due to electric short circuit. This case is this fact is the, yeah, or the rather the outcome is the outcome of this second case. The third one is Holmes versus Mathur. So this is related to defendant's servant would not control the horse could not control the horse due to barking dog. This is the fact of the case. The fourth one is nitroglycerin case, and this is related to explosion due to unknown contents in a box. So you just have to, for this question is for revision purpose. You just have to remember all the facts. We will dwell upon the different aspects as well in the upcoming questions. So just get ready. Question number 6 is, in Assam State Corporation versus Srimati Anubha Sinha, an accidental fire occurred in the premises due to defective electric wiring, which the landlord failed to repair despite the tenant request. So this is a fact, although I consider do not providing facts, but for the purpose of discussions, we are providing here you facts. Otherwise, you have to remember at least some of the cases. So on the basis of this facts, there is assertion and there is reason. You have to choose the options accordingly. The first one is the tenant was not held liable for the accidental fire. This is the assertion. In this case, the tenant was not held liable for accidental fire. And the second word is that the landlord had failed to repair the defective electric wiring which caused the fire. This is the reason. So if you see carefully, if you remember this case, we have discussed this in a video of inevitable accident. So this is absolutely correct. Assertion is also correct. The tenant was not held liable because tenant has informed the owner or the landlord that the electric wiring is defective, but the owner or the landlord had not taken the you know consideration taken into account the consideration, and he omitted to repair the defective electric wire. So the reason, and that is the main reason for the fire broke out because of this defective electric wire. So all assertion A is also correct, reason is also correct. So the option number A, that is both A and R are correct, or R is the correct explanation of A. This is the correct answer. So A is the correct answer. Now coming to the next question, question number 7. Which of the following statements best reflect the rationale behind not holding a driver liable for an accident caused by external factors such as a startled animal? Which of the following statements which of the following statements best reflect the rationale behind? Just give me a second. I just turned off the notification that is coming again and again in my videos. So sorry for that. Now, so the question number 7 is, which of the following statements best reflect the rationale behind not holding a driver liable for an accident caused by an external factor such as a startled animal? You know, we have to find the best that reflect the rationale behind not holding the driver who is driver liable for an accident caused by external factors such as a startled animal. So this is something related to Holmes versus Mather facts, wherein a person is driving horse, and there is animal, there is a dog which barked, and that made the horse startled, and that eventually led to the horses running here and there, and this caused the damage to other persons. So in what rationale, in what could be the based reason that the driver was not being held liable? So let's read all the options. The first is the driver should always be prepared for an eventuality. Second is accident caused by natural reactions of animal are beyond human control. Third is the driver must be held liable to ensure accountability. And the fourth one is the driver should have taken better measures to prevent such incidents. So if you see all the options very carefully, you will find that the accident caused by natural reactions of animals are beyond human control, and that is the main, you know, correct answer. So if you see, but again, if you have read the case of Holmes versus Mather, we have studied in a video. So if you see it, therein we have studied that it must be, there must be no negligence, there must be reasonable care, due care. So that part always come in a tort cases. So yes. So coming to the next question, question number 8. In S. Vedantacharya versus Highway Department of South Arcot, a bus passed over a culvert that gave way due to an heavy rains and flooding, resulting in the death of one of the person. The highways department had not made suitable provisions to strengthen the culvert against such foreseeable natural events. So why was the highway department held liable for an accident? Yes, if you see, you know, the heavy rains and floodings, the highway department in this case, if you remember, they were held liable, and the reason is very very clear, that the highway department have responsibility and they have to foresee, they have to foresee. Just because a bus is passing to a culvert, it could not be possible, it could, even if there is a heavy rains and floodings, but the department failed to make suitable provisions for heavy rains and flood that could be anticipated, that could be anticipated. This is the most correct options available here. The department had prior knowledge of the defect. It may or may not. Even if it not, they could have foreseen. They should have foreseen. There is a foreseeability part. The first, so option number D is correct. Other options are not correct. Question number 9. In the nitroglycerin case, the defendants, a firm of carrier, were given a wooden case for transport. They were unaware that the case contained nitroglycerin. Finding leakage, they opened the box in their office building, causing explosion that damaged the building. So, in this case, the defendant is the person who are the carrier. They were given a nitroglycerin, box for transport, but they were not very aware about that. They were unaware about that. So, there was a leakage in the box. So they just took the box and come to their office building, and therein they when they open for repairing the leak part, the nitroglycerin blasts and damaged the building. So the building authority, so the building owner, basically filed a case against these persons, the defendants, to compensate. So why were defendants not held liable for explosion? What could be the reason? If you read all the options, let's read all the options. The option number one is the defendants knew the contents of the box. This option number B, the explosion was intentional. Option number C, the defendants could not reasonably suspect the box contained dangerous substance. And fourth is the plaintiff contributed to the accident. No. So option number D is not. Option number C, intentional. No. Option number A, defendant knew the content of the box. No. Option number C is the correct. Option number C is the correct. Although if you have read the facts, you can easily find out without even going into the other options. So let's move forward. Question number 10. Just don't think go into the length of the questions. These type of questions are being asked in many competitive examinations. You know and most of the time we found it in the examination very difficult, but it is the only main reason that these questions are not being, you find it very difficult, is that you have no practice of reading books. If you read books regularly, no question come out of the box. Believe me, no question can come out of the box. You can easily manage or handle any of the questions. Just you have to read books, just have to you practice. This is the only thing. So let's read it. This is a statement. I have intentionally given this a statement in this question. Lord Dundon in Pardon versus Hard Court. This is the statement that was in the footnote of the book. So I have gone into such detail, because on all to help you. So just you have to at least do hard work. So the first is, so this statement could be asked in any mains examination as well, in pre-examination as well. You have to ready for that. So let's read it. If the possibility of a danger emerging is only a mere possibility which would never occur to the mind of reasonable man, there is no negligence in not having taken extraordinary precautions. People must guard against reasonable possibilities, but they are not bound to guard against fantastic possibilities. So if you read this, and let's read the facts. What is the question on the basis of the facts? So in a negligence case, the plaintiff argues that the defendant should have taken extraordinary precautions to prevent a highly unlikely accident that injured the plaintiff. Second is, this defendant argues that the possibility of such an accident occurring was so remote that it could not occur to the mind of a reasonable person. So, in a negligence case, both the plaintiff and the defendant, give their points. They argue on their points. On based on this above statement, you have to choose what the court likely decisions could be. So the option number A is the defendant is liable because any possibility of danger requires extraordinary precautions. The defendant is liable because any possibility of danger requires extraordinary precautions. Second is the defendant is not liable because people are not bound to guard against fantastic possibilities. Third is the defendant is liable because the accident occurred. The fourth is the defendant is not liable. The defendant is not liable. The defendant is not liable. I cannot see it because there is an issue. So what is the yes? Not liable because the plaintiff failed to prove negligence. Plaintiff failed to prove negligence. So all these things are not these things are not correct. It could not be, you know, the obvious statement that the court likely to decide is the option number B, on the basis of law intended in statement or the observation, that people are not bound to guard against fantastic possibilities. The negligence, in case of negligence, it is not we can accept from the person, we can expect from the person that he will do something extraordinary to prevent the prevent some damages. He cannot do. We can only expect maximum to a reasonable prudent person, you know effort. So that is the point in this case. Question number 11. Let's read the fact first. So, in Nichols versus Marshland, the defendant created some artificial lakes by damming natural streams. An extraordinary heavy rainfall stated to be the highest in the human memory, caused the embankments to give way, resulting in the rush of water washing away four bridges belonging to the plaintiff. Which of the following statements are correct regarding the court's decision? What would be the court likely decision? So, we already have discussed this case. Now, let's see the options. So, first statement is the defendant was not liable because the damage was caused by an act of God. Second is the defendant did not adequately reinforce the embankments. Third is the extraordinary heavy rainfall was the primary cause of the damage. Fourth is the plaintiff was responsible for maintaining the bridges. So, if you see statement 1 and statement 3, both are correct, and both are in the way giving reasons for the third one is gives the reason, main primary cause of the damage, and the first one is stating that this is an act of God. So option A is correct. Only 1 and 3 are correct. Other options are not correct. Question number 12. In Ramlinga Nadar versus Narayan Reddyar, the defendant's lorry was transporting goods when an unruly mob robbed the goods. The defendant argued that robbery was an act of God. So if you see, this statement is also, this case we have also discussed. So there is one assertion and one reason on the basis of the same facts. The assertion is the defendant was held liable for the loss of goods. Reason is the criminal activities of the mob did not qualify as an act of God. So see, we have studied this reason is herein very correct, because it is not an act of God, and if it is not an act of God, the defendant will definitely not held liable for the will not will held liable for the loss of goods. So both assertion and reason both are correct, and both reason explains the assertions. Reason is the correct explanation. So option number A, both A and R are true, and R is the correct explanation of A is the correct answer here. Question number 13. Question number 13. Let's see. In Kalulal versus Hemchand, the wall of a building collapsed on a day with 2.66 inches of rainfall, resulting in the death of two children. The defendant argued that the collapse was due to an act of God. Now, if herein you have to analyze your experience. So 2.66 inches of rainfall is not very heavy rainfall. It's a normal rainfall. It can occur in a rainy season. So this is perfectly a type of negligence. Which of the following statements are correct regarding the court's decision? So what would court decide in this case? Defendant was held liable for the collapse. Yes, definitely he will be held liable for the collapse because he has not maintained he should have maintained, he could have maintained only of 2.66 inches of rainfall. It is not sufficient to collapse of a building. It means that building was not repaired. So first is obviously defendant will held liable. Let's move to the other options. The rainfall was considered extraordinary and unforeseeable. Definitely not. Third is that the defendant failed to anticipate and guard against the possibility of collapse. So yes, 3 is the correct. And fourth one is the defense of act of God was accepted. So no. So only 1 and 3 are correct. Option number A is the correct option. Now let's move to the question number 14. Question number 14 is in Bird versus Holbrook, the defendant set up a spring gun in his garden without warning signs. A trespasser was seriously injured by one of these guns. So the question is, why was the defendant held liable for the injuries caused to the trespasser? Why was the defendant held liable? So if you see all these statements, let's read first. The trespasser should have been should not have been in the garden. Second is the defendant was negligent in maintaining the spring guns. The defendant was negligent in maintaining the spring guns. The third is the force used was greater than what was necessary to protect the property. The fourth is the trespasser ignored warning signs. So clearly, the statement C or the option C is correct here, because setting up of spring guns is very deadly. It cannot be the force. It cannot be the force one can utilize to protect the property. And if it is so, it should be with the warning signs. Question number 15. In Ramanuj Mudali versus M. Gangan, the defendant, a landowner, laid live electric wires on his property without any visual warnings. Again, a live electric wires without visual warnings. The plaintiff was injured when crossing the property. So, in considering this fact, what was the court rulings regarding the defendant's liability? So, again, if you see, the defendant in this case, the defendant was liable because the use of electric wires was excessive and without warning. On the same, on the same principles of private defense, you cannot use excessive force. So yes, it was excessive force that you cannot use. Now coming to the question number 16. In a neighborhood, Mr. Collins noticed a trespasser, Mr. Bird, nailing a board to a wall in his garden. To protect his property, Mr. Collins gently shook the ladder, causing Mr. Bird to fall and injure himself. So, based on the incident between Mr. Collins and Mr. Bird, which statement are correct regarding Mr. Collins' use of force in defending his property? So, let's see the statements. The first statement is Mr. Collins was justified in using the force to protect his property. Second is the force used by Mr. Collins was excessive and disproportionate to the threat. The third is Mr. Bird was trespassing and deserved to be injured. Fourth is Mr. Collins should have verbally warned Mr. Bird instead of using physical force. The fifth is the court is likely to hold Mr. Collins liable for the injuries caused to Mr. Bird. So if you see all these statements herein, and if you remember this case also, even if you do not remember the case, you can think of, just you can imagine the situation. A person is nailing a board, and he has reached at the top of ladder, and you just watching Mr. Bird on the ladder and nailing a board, you just shook the ladder. Could it be the best way to protect the property? Yeah, definitely there is possibility. If someone is on the top of the ladder, it is possibility that he will, if he fall, he will severely injured. So definitely this could not be the justified use of force. This force could not be justified. The correct way could be Mr. Collins should have verbally warned Mr. Bird instead of using physical force. So the court is likely to hold Mr. Collins liable. Considering all these statements, if you see correctly, so we'll see that first statement is definitely correct. The second, the third, sorry, the fourth statement is correct, and no, sorry. The second statement is correct. The force used by Mr. Collins was excessive and disproportionate to the threat. Then fourth statement is also correct. Mr. Collins should have verbally warned Mr. Bond instead of using physical force. And the last one, the last statement, the court is likely to hold Mr. Collins liable for the injuries caused to Mr. Bird. So all these two, four, and five, if you see, B has a B has two, four, and five as correct. So this will be the correct option. Coming to the question number 17, there are five facts. There are five statements, five facts. We have to read first all the facts. So let's read first all the facts. Alice has a fierce dog to guard her property. One night, a person starts climbing over her fence. She commands her dog to attack, resulting in severe injuries to the intruder. Just highlight the portion that will be helpful in answering the question. So, commands her dog to attack. Second is Bob, while walking his dog, sees another dog aggressively charging towards them. Fearing for his dog's safety, he pulls out a stick and strikes the approaching dog, causing injury. The third one is Carol sets up a high voltage electric fence. High voltage electric fence. And just highlight, pull out a stick and strikes. High voltage electric fence around her garden to deter trespasser. There are no warning signs. Again, no warning signs. A neighbor unaware of his fence gets severely injured while retrieving a ball. Fourth is David, a shop owner, notices a person trying to steal from his shop. Trying to steal from his shop. He locks the door He locks the door, trapping the person inside until the police arrives. Fifth is Ellen, hearing noises at night, shoots a warning shot from her fireman into the air, scaring away potential intruders but accidentally hitting a passing bird. So let's see the questions based on the principles of private defense. Which of the following conclusion are correct? So first statement is Alice's use of force was reasonable and necessary to protect her property. Second is Bob's action of striking the approaching dog was proportionate to the threat. Third one is Carol's use of high voltage electric fence without warning signs is considered excessive force. Fourth is David's action of locking the door was reasonable to prevent theft. And fifth one is Ellen's warning shot while aiming to protect was excessive and careless. So if you see the facts and analyze the statements given herein, you will find that yes, she commands her dog to attack. This could this could not be reasonable and necessary. This could not be reasonable and necessary. Even without even without commanding a dog to attack, it could have been done other ways. Second is Bob action of striking and approaching the dog was proportionate to the threat. Again, when one dog see another dog, it is possibility that he will start coming to the other dog. So it is not a correct way. You cannot you just pull out a stick and strike to the dog, no, because it is a natural dog reactions when they see other dogs. So this could also be not a correct statement. Third one is Carol's use of high voltage electric fence without warning signs is considered excessive force. Yes, it is excessive force. Fourth is David action of locking the door was reasonable to prevent theft. Yes, this is a best course you can do, because the person who has tried to steal from the soap, he has done a act of theft. So it could be a possible way. So fifth statement, if you see Ellen's warning shot while aiming to protect was excessive and careless. Yes, she fired. Does it require does it require to fire? Why would you require to fire in the air? So, and if you even if you fired, you cannot just you cannot fire just carelessly. So this is also not a correct way. If you see all these statements, we find that this statement 3, statement 4, and statement 5, all these are correct statement regarding the private defense, the use of private defense. So this will be the option number C will be the correct. Question number 18. Facts. Two facts. Just read it first. Jack enters Jill's property thinking it his own due to a misunderstanding about property boundaries. Due to a misunderstanding about property boundaries. है ना? And second option is Ema takes an umbrella from a restaurant, believing it to be hers, but it actually belongs to another customer's. This is a question, by the facts itself, or you can understand that this could ask the question based on the principle of mistake as a defense. So, based on the principle of mistake as a defense in tort law, which of the following conclusion are correct regarding Jack's and Ima's action? First is the statement one is Jack's entry into Jill's property is considered trespass regardless of his mistaken belief. Second is Ima's taking of umbrella is considered trespass to goods regardless of her mistaken belief. Third is both Jack and Ima can avoid liability by showing they acted under an honest but mistaken belief. Fourth is neither Jack nor Ima can avoid liability by claiming a mistake of fact. If you see all these statements carefully, you will find that option number 3, can avoid liability, it is not possible, because in these case of trespass to land or trespass to goods, mistake would be a very weak defense, very weak defense. And considering all the options herein given, you can absolutely think of that option number 3 will be incorrect. And when the option 3 will be means statement 3 will be basically incorrect, so option C will be the correct answer. Only conclusion 1, 2, and 4 are correct, because automatically if 1 and 2 are correct, it means that option number 4 will be automatically a correct statement. Question number 19, which is correct? First statement is honest belief in the ownership of goods is not a defense to an action for conversion. Second is mistake of fact does not absolve liability for trespass. Third is vicarious liability can be avoided if the servant's mistake was outside the course of employment. And fourth is mistake of law is a valid defense to tort action. So option number four is itself very is not correct. Mistake of law is not a valid defense in tort actions. If you see other statements are all correct. Honest belief in ownership of good is not a defense to an action for conversion, because then in any case everybody will always say that he had the honest belief that his the goods belong to him, but it could not be so, it could not be accepted as a valid defense. It is a mistake, and such a mistake will not be, will not be allowed in law. The second is mistake of fact does not absolve liability for trespass. Yes, that is the fact. That is the correct statement. And third one is also correct. Till now, we have not discussed the vicarious liability in tort law in our videos. But yes, if something is done by servant in outside the course of employment, vicarious liability will not will not be a liability. Vicarious liability will actually avoid the liability for the master. So 1, 2, and 3 all are correct. Means 1, 2, and 3 all. This statement is correct except 4. So option number C will be the correct. Now coming to the next question, question number. So this was the correct question number 19. Now coming to the question number 20, the last question. This is a statement based on Halsbury's laws of England. So you have to fill in the blanks. This question has been, given. This question has been prepared by me intentionally to remember, to let you remember what all we have discussed and what could be asked in examinations. So just remember, just try to fill it. An act of God in the legal sense may be defined as an extraordinary occurrence of circumstances which could not have been foreseen and which could not have been guarded against, or more accurately, as an accident due to natural cause, directly and exclusively without human intervention, and which could not have been avoided by any amount of what dash and dash reasonably to be accepted of the person sought to be made liable for it, or who seeks to excuse himself on the ground of it. The occurrence need not be unique, nor need it be one that happens for the first time. It is enough that it is extraordinary and such as could not reasonably be anticipated, and it must not arise from the act of. If you see all these statements, if you all see all the options here, so act of what? Animal? No. Nature? You know, obviously no. It must not arise from the act of. It is something about an act of God. So it must not arise from the act of accident. So if you see other statement, let's see other fill in the blanks. So it avoided by any amount of, if you try to reach out the correct option, if you see, if you let's see the B option. So have been avoided, not have been avoided by any amount of foresight and care reasonably to be accepted. So this should be the based one. This should be, this should be based one, because even if you see, take this option C. So effort and attention, if even if you, fill in here, but the third one is nature, which will not be the correct here. So definitely option B will be the correct. Now all the questions we have completed, all the questions. Now let's move to the super over final questions. If anybody have a, same number of answer correct and same number of answer wrong, so let's a tiebreaker question. Which of the following statement correctly align with the principle of tort law? For a statement, four defenses we have discussed today. So first is an inevitable accident include event where the defendant took all possible precautions but still could not prevent the damage due to sudden and unexpected natural causes. It is a correct statement. Second is an act of God does not include events that occur frequently, but rather those that are rare and extraordinary and cannot be reasonably anticipated or defended against by human foresight. Again, a correct statement. Third is private defense justified the use of force only when there is an immediate and credible threat. Preemptive or retaliatory force is not covered under this defense. This is a principle of private defense. Fourth is mistake of fact may excuse liability in tort law if the mistaken belief was induced by plaintiff's action and defendant acted reasonably under the circumstances. Induced by plaintiff's action and the defendant acted reasonably under the circumstances. So if you see all these statements are here incorrect. May excuse liability in tort law. may excuse liability in tort law if the mistaken belief was induced by the plaintiff's action and defendants acted reasonably under the circumstances. So fourth statement is also correct. It means that the option D, all statement one, 2, 3, 4 are correct, will be the correct answer. So this marks the end of series 5. We will discuss remaining general defenses like necessity and statutory authority in the series number 6 of Test Your Knowledge and Experience series. I hope you have enjoyed the series 5. And if you want to solve daily MCQs, you can reach out at the community post of the Legal Researchers YouTube channel, wherein we discusses daily MCQs. We solve daily MCQs. So get ready. We will climb to the top of mountains together. Thank you very much for participating in this cues, and we will meet soon in the series 6. Thank you very much once again.